Welcome. Today we're going to be covering the Guide to Computer Forensics Investigations. This is the 6th edition. The material all comes from Cengage. They own and control all copyright material. I'm just providing video lectures on the individual chapters for my courses using this textbook. My name is Arthur Salmon, and I'm going to be working with you throughout this book. Thank you. Chapter 16, Ethics of the Expert Witness. This is actually a really interesting chapter because this deals with the credibility of the person presenting the evidence. We're going to explain how ethics and codes apply to expert witnesses. We're going to explain how other organizations' codes of ethics apply to expert testimony. We're going to describe the ethical difficulties in expert testimony. And we're going to explain the process of carving data manually, even though that's not really applicable to this chapter, but we're gonna go over it. The big thing all of this has in common is expert witness credibility and trustworthiness. All right, let's go ahead and jump right on in. All right, so with that said, ethics, they are the rules you internalize and use to measure one's performance. A code of professional conduct or code of responsibility are standards that others apply to you, or there's some form of compelling you to adhere to those external forces. Might be a licensing body, might be a certification body. It really depends on your profession. People need ethics to maintain their balance. Basically, it's more of a self-respect and respect to their profession, but again, ethics are kind of how we internalize our own code of conduct, our own set of standards that we live by. Normally there is some form of rules, regulations, even ordinances or laws that will govern codes of professional conduct and responsibility. Again, this is what, as a professional, you should be doing. This will define the lowest level, the minimum level of action or performance required to avoid responsibility or liability. Expert witnesses should present typically an unbiased, yet specialized and technical evidence perspective. Normally this is presented to a jury. Basically, control your bias and don't allow your bias to control you. You want to have your opinions based in fact, not your own tainted lens or your own bias. Expert witnesses will testify in more than 80% of trials, and in many trials, multiple expert witnesses are going to testify. And sometimes on both sides of the courtroom, different or opposing expert witnesses will testify even on the same set of evidence. So that is why credibility and trustworthiness is so important. So what are some rules that are applicable to attorneys and witnesses? Well, these are the rules of evidence. Experts are bound by their professional ethics and the ethics of their professional organizations to follow a very specific set of guidelines. In the U.S., there is no state or national licensing body for digital forensics examiners as of yet. So your source of ethical standards are your internal values and codes for professional associations that you might belong to. Now, there are some international organizations for digital forensics that do set up a set of ethics that one could adhere to, but they're in the US right now. There is no specific group that we're aligning to as of yet. So what's the role of the examiner? So with digital forensics examiners, they have two roles: fact witnessing and expert witnessing. As an expert witness, you're going to testify even if you weren't present when the event occurred. You don't have to handle the data storage device personally to be able to speak on its behalf. There are some criticisms here. It's possible to find and hire an expert witness to testify to almost any opinion, so we need to be aware of that because there are attorneys that will opinion shop. That doesn't necessarily mean it's a good thing. One of the more effective of violating the court rules or laws is disqualification. When you do something, especially as an officer of the court or as an expert witness, you can be disqualified. So the opposing counsel might attempt to disqualify you based on a deviation from opinion, or you given something from a previous case, or testing your credibility. Some attorneys will contact many expert witnesses as a ploy to disqualify them or to prevent opposing counsel from hiring them. If there's only 100 people in town that do what you do, and opposing counsel contacts 90% of them, well, you can't use them. So to determine who the parties are to reduce the possibility of a conflict, this makes it a little bit more complicated. Whenever you are aware of a possible disqualification issue, you should bring it to the attention of the attorney who's retaining you. You need to bring it up and be like, hey, I may not be the appropriate person. Factors might include whether the attorney has informed the expert that their discussions were confidential, whether the expert reviewed material marked as confidential or worked on any product that was confidential, or whether the expert was asked to sign a confidentiality agreement. So if any of these are held true, then it may disqualify you. Factors that disqualify also include numbers of discussions held over a period of time, types of documents that were reviewed, types of information conveyed to the experts, the amount of time involved, as well as discussions or meetings between the experts and the attorneys, whether the expert provided the attorney with confidential information, and lastly, whether the attorney formally retained the expert or if this was hearsay or opinion-based. A few other things might of concern are whether the expert's voiced concern about being retained or not, as well as whether the expert was requested to perform services for that specific attorney or other attorneys, and whether the attorney has compensated the expert. Depending on these considerations, there might be a disqualification clause. And again, part of this is going to be based off of your state, based off of your federal or your government regulations, and your country. A big part of this is you're going to be working with general counsel or an attorney to identify which areas apply to you in each specific situation. So, with all of these disqualification notices and clauses and things that might trip up an expert witness, are there anything else that we need to be aware of? There are traps. So be cautious about some of the following items. What are some of the differences between the attorney's motives and the investigator's duties? The attorney has a responsibility to their client regardless of the investigations. So do keep that in mind. Is there a function of the expert witness that will conflict with the investigator's code of conduct? Should you anticipate that the opposing counsel will look at your organization membership and those codes of professional responsibilities? Is there going to be anything that the opposing counsel can target you, the individual, being the investigator? Are there any contingency fees? Because these are not allowed except in very specific circumstances. And again, you're going to be working with general counsel to determine what is legal and what is not legal. You want to avoid ethical errors, altering data, presenting false information, reports that work that wasn't really done, ignore available contradictory data. If you are investigating and you happen to find evidence that something may or may not have occurred, you have a responsibility to report accordingly. Do not work beyond your expertise. Work within your appropriate level. Allow the attorney who's retained you to influence your opinion. Again, you're supposed to be unbiased. You're supposed to be factual-based or fact-based, not feel the pressure of anyone else. Don't accept the assignment if you cannot reasonably do the work in the appropriate time. A lot of organizations will put, a very fast rush and not give the investigator the appropriate time to perform the investigation. Being rushed leads to errors. Don't reach a conclusion before completing the investigation. Don't fail to report any conflict of interest. If there's any concerns, you need to report it first and foremost. You want to be mindful of what you can actually admit as evidence. So hypothetical questions give you the factual structure to support and defend your opinion. Although expert opinions can be presented without stating the underlying factual basis, there are concerns with this. The testimony isn't admissible if the facts on which the opinion is based are not adequate enough. There is not enough evidence to allow stating a legitimate opinion without the factual content being there. So again, it needs to be based off of facts that are able to be presented. No single source offers a definitive code of ethics, so we do need to keep that in mind. You must draw on standards from organizations that form your own ethical standards. And not everyone's ethical standards may be the same. That is why they keep bringing up organizational or professional level of standards. That way, those organization and groups should influence the individual and the investigator, as well as the expert witness. Many organizations will have rules to guide their members in such areas: interactions, objectivity, roles in society, solicitation of services, fees, contractual relationships, and more. The nice thing is there are some international organizations like the ISFCE, and they do include some guidelines. They maintain the utmost objectivity for digital forensics investigations, codes of conduct, codes of examinations based on established methodologies, testifying truthfully in all matters, and avoiding any actions that would appear in conflict, thus making sure the highest level of credibility and trustworthiness of their members. ISFCE includes things like never misrepresenting training, credentialing, or association memberships. Also, never revealing any confidential information learned during an examination. Other groups for high technology investigations are the HTCIA. Core value here will include truth uncovered with digital evidence and its effective techniques to uncover the truth. Essentially, their big motto is no wrongful convictions. The HTCIA values the integrity of the members as well, and that including following best practices, including all specialized techniques, methodologies, and methods for gathering digital evidence. Other international groups like the IACIS maintain the highest level of objectivity for all digital forensics and accurate presentation of findings, thoroughly examining and analyzing digital evidence, conducting examinations based on established valid methodologies, rendering opinions based in fact, as well as things that can be demonstratively responsible or reasonable, not withholding any findings that could cause facts of a case to be misrepresented or distorted. Again, so you've seen that these are the three main groups, but all of them outline presentation of data through factual, methodical methods that follow best practices. Other groups might be the American Bar Association. That's for attorneys, but these are some of the rules that some investigators need to follow through. So be aware of the basic rules of professional conduct that attorneys have to follow. The Bar Association does model a code of professional responsibilities, and the successors, the model rules of professional conduct. These are the basis of the licensing board for each state. The Bar Association has stated that expert witnesses do not owe a duty of loyalty to their clients. They are supposed to be unbiased, and with that said, they are supposed to present findings in a factual manner that have only been completed once the investigation has come to a complete end. And that means the investigator has to have the due diligence and the time to properly analyze all of the evidence in the case before presenting their opinion. There's also the American Psychology Association, APA, and they also outline a principles of codes of conduct or ethical principles for psychiatrists, commonly referred to as their ethical code or ethics code. These guidelines offer comprehensive regulations with an entire section devoted to forensics activities. Digital forensics is just one form of forensics. There are multiple forms of forensics, so the ethical component can be inferred from other bodies. What happens if there is a conflict, though? There are ethical difficulties. So if there is an inherent conflict between the goals of the attorney and the investigator, that needs to be reported, and the investigator should step away. A big thing to understand is that attorneys work in a more adversarial system, and they're always looking for ways to get their way, whether it's swaying the judge or the jury. Again, legally, within their system, they're always looking for an advantage. That is why the ethical component of a digital forensic investigator or expert witness needs to be above reproach. The credibility of that individual is crucial. Science requires experts to focus on the evidence regardless of influence. There are guidelines to help allow the investigators and allow the experts to do this. This can be challenging. Experts to choose between impartiality and responsibility that they're advocating, but again, the expert and the investigators need to follow factual data based off of evidence to support their opinion. It's not what they think, it's what the facts of the case and the evidence says. However, there are concerns. Realistically enforcing any type of ethics or guidelines, it's not as easy as it may seem. It is very difficult. Principles that can be enforced only against members of that organization. Meaning if you're not a member of that organization, well, guess what? You don't have to contend with their set of guidelines. All guidelines rely primarily on the internalization of the codes and witnesses. Analysis of when and how, the methodologies, how they participate in the case, and so forth. If these guidelines aren't enforced, then what good are they? Available guidelines only set the bare minimum level of acceptable performance. That doesn't mean it's the high level, it's the bare minimum. And oftentimes, users are only going to do the bare minimum, if that. The interesting part is we've always talked about ethical responsibilities from the standpoint of the investigator or expert witness. However, your general counsel has a responsibility to you as well. They owe you a fair statement of the case or situation. So before the expert witness should come on, the attorney has a responsibility of providing certain information. Adequate time to review the evidence as well as prepare a report. They also a reasonable opportunity to examine the data, conduct the testing, perform the investigation before rendering an opinion. They need to give you the allotted time to do this. It's not a one and done, you're rushed, but they are responsible for giving that component to you. Most attorneys, including opposing counsel, are competent, courteous professionals. And that's very, very, very subjective because I've seen both sides of that. Some opposing counsel will attempt to make discovery depositions physically more uncomfortable. After noting the problem, you can definitely refuse to continue with the deposition if necessary. As a measure of protection, you might want to have your own attorney, not the attorney that you're working with, but your own personal attorney. That way the investigator or you, the expert witness, are protected. This attorney can't object to the questions, but it is available to advise the attorney who's retained you or to advise you what is or is not allowed to be said. Again, like, they can't really do much but give you advice while the deposition is underway. The case's attorney is again responsible for the case. You, the investigator, or you, the expert witness, having their own attorney, is there to protect you, not the case. Just in case there is a conflict, or just in case there is something that might prevent the attorney on the case from having your side. Because again, the attorney on the case, their responsibility is to the case, not to you, the expert witness or the investigator. Can you, the investigator, provide your own tools? The tools you use to recover, control, or track evidence are subject to review by the opposing party. So if the court does deem them unreliable, guess what? Evidence collected through those tools are thrown out. So you have the ability to use your own tools, but if your tools are not accepted by the general body, especially in digital forensics, then guess what? They're not going to be valid. So if you use standard tools, you simplify the process for validating them. Because again, all of the tools need to be validated, and having the tools used as part of the general board of digital investigators, that right there allows validation to be a lot easier. Personally, creating the tools might have advantages that you can demonstrate to a judge, but you have to prove validity, you have to prove reproducibility, you have to prove a certain level of work before they're allowed to be admitted. And again, that's up to the individual judges and the counsel. The counsel being the attorneys. All right, so let's try an ethical exercise. Do the following activity at the end of the chapter. Perform the cursory exam for a forensics image. Detail the exam image. Perform the exam. Interpret the appropriate data runs as part of the end of course, the end of the chapter component. So performing the cursory exam for a forensics image. Performing the detail exam looking at the hexadecimal values, and then perform the exam. So maintain the highest possible ethical standards when conducting the investigation, develop your plan, review it, start your analysis. Interpret the data runs. If you are looking at the data run, you should be able to carve out the data, and you should be able to retrieve a Kayak 4 JPEG. If you want to manually do it. Realistically, I try really hard not to manually carve out things. I normally use a forensics tool to do the carving, but this is something that you can do. That is it for this chapter. We looked at ethics. We looked at the examiners, their code of conduct, what you owe your client, what the attorney owes you, looking at ways to disqualify you as an expert. We looked at the court's use of many factors for determining how to disqualify an expert. We looked at obvious ethical errors. We looked at single source for definitive codes of expert witnesses. We looked at international groups for codes of ethics. And we looked at inherent conflicts between the systems, as well as how to recuse yourself. We looked at responsibility of the attorney. We looked at general tools, and we looked at carving based off of a end of chapter exercise. And again, the end of chapter exercise we're going to be completing in our lab component of this video series. Questions or anything, please feel free to reach out. Thank you. All right, now that we've wrapped up some of the material for this chapter, are there any questions? There's a lot of different material covered, so again, the key thing is, as you're going through the material, whether it be the reading, whether it be the videos, ask questions, write questions down. The more that you can engage your brain in this material, the better you are at retaining the information. So again, questions, please feel free to reach out, and we will go from there. Thank you, and I look forward to working with you throughout the remainder of these modules.